All right, now we're going to move to the coalface of sanctions. We're going to start talking to the people who have to make a living trying to comply with these rules that are being written, and also those whose job it is to enforce the rules in the UK. We're very lucky to have Rena Lalgie, the head of the Office of Financial Sanctions Implementation in the UK, with us today. And on the front line to discuss these issues, we have William Dodsworth from Barclays. To my left, we have Andy Wragg from AXA, and before that, Lloyd's. We have Susan Lake from Swiss Re, and we have Sidanius from Thomson Reuters to my immediate right, and all the way to the left, we have Tom Keatinge from the think tank RUSI. And their full bio notes are obviously in your program. Now, obviously, there's a limited amount anyone can say about compliance before we've seen the detail in the statutory instruments. But a number of companies are, of course, already taking advice and gearing up now. Can I start with Andy, then? From the perspective of the insurance industry, how is the feeling that Brexit is likely to impact on the industry from the perspective of sanctions? And what, if anything, can they do to prepare now?
Okay, thanks, Maya. I came in today hoping I was going to have a lot of reassurance from the previous speakers about what I jotted down was that we have a third set of sanctions regulations that we have to follow. We're going to have more pain and consternation and increased compliance costs. I think having heard about the Henry VIII Act and the ministerial discretion, I think quotes I put down, lots of turmoil ahead, short-term alignment with the EU, and then I put but ... and then an independent foreign policy approach that we've always had, but of course now unshackled from the EU. And I just thought, well, okay, I feel a lot more comfort now. Compliance is going to be easy. I mean, the reality is, if I can take where I was previously and where we are now, insurance is an international business. It's got lots of international clients. We often have to comply with more than one regime. It's a fact. We're across borders. We've got branches in different places. It is an incredibly complex thing, and I think that if we've got another third way, it's not going to be easy, and compliance costs are going to be huge. Doesn't mean to say we get the resource that goes with it, of course. And then there's other things that I thought of, okay, the UK can be quick. It can be quick in implementing, but if it's not wanting to implement what it's seen in front of it from the EU, it may be very slow. It may choose not to do things, and we may be sitting there at the coalface thinking, what's coming next? Obviously, I'm quite happy about the fact that we have a strong enforcement regime in the UK, but we have a strong enforcement regime in the UK. So, that's something we definitely have to consider. That hasn't always been seen to be the case. And we even heard about the EU taking more prosecutions for lack of fair trade. EU blocking legislation. How do you follow that? So there's lots of things that I won't dwell on any longer, but there's a lot of things that just don't make it seem a very easy road ahead for us that are expected to be the frontline police, as the first line of defence, as it were.
And Che, as a major data provider on sanctions data, can you just explain a bit about how Brexit might complicate matters from your perspective, if indeed it does?
Yeah, sure. So thanks first of all for the invite. When Maya told me about the topic of today of Brexit and the impact of sanctions, I said that's a very good question. We just really don't know in the private sector. We've heard a number of different policy positions and from a legislative perspective. But for us as a company, I don't think it's going to be that much of a deal. I mean, we already cover 240 countries, 65 languages. across a spectrum of different financial crime factors, sanctions just being one of them. So for us, it's not going to be, that big of a deal. But for organizations like financial services firms and corporates, for that matter, it's potentially going to be a big deal, because it's not the sanctions and Brexit itself, it's what it represents, which is a further political fragmentation, policy fragmentation, economic fragmentation that's becoming increasingly complex to manage, number one. Number two, the sanctions regime, as we've heard before, in the US is going to be applied in a much more stringent way to advance US foreign policy. We're also seeing the financial sector being used not just as instruments of foreign policy, which is by its very nature, but actually being used against all traditional allies. The Trump example of pulling out of the Iran deal is one example. We already know from my discussions within the European context, within the Brexit context, that financial firms and non-financial firms are going to be used as a form of statecraft against each other. So for me, that is the real worry, and how we resolve that from a policy perspective is going to be a real challenge. Now, us as organizations, so we are a data provider. We provide data to banks and insurance companies and corporates based on open source data. So we are that open source intelligence sharing provider. So the question then for us is, well, how do we, what business models do we need to think about in terms of making sure that we provide the services that our customers need to adapt to the new situation? So that's a piece of work for us to do. So hopefully that gives a context in terms of what I really see the issues are. The Brexit and the sanctions regime on its own is not the issue. It's actually the manifestation of a much larger problem that's going to aggravate. I think it's going to be much more difficult to manage going forward. Yes, we may start off from the same alignment space within Europe and the UK, but there's no question there's going to be divergence. There's going to be political divergence, whatever the UK, what role it sees itself going forward. And that for me is a bigger worry. It becomes a much more complex compliance issue and much more difficult political issue.
Rena, just to bring in your views here, OFSI is a relatively new organisation still. It's been in existence, I think, almost exactly 2 years now. And your job is obviously not formulating sanctions policy, but investigating and imposing penalties for breach and granting exceptions. So from your perspective, how are you gearing up towards transforming yourselves into the UK being an autonomous regime for the first time?
Thank you. And I think, as a number of people have touched on across the panels, it's worth being clear that, of course, the implementation and enforcement of financial sanctions is currently a domestic competence, whereas there'll be some more fundamental change potentially in the sort of legal and policy context. So, on one level, I think for us and what we do on a day-to-day basis, in the very similar way to what sort of compliance professionals do on a day-to-day basis, there may not be much change in terms of what we have to do, but undoubtedly the operating framework changes for us, and there are a few things that it's probably worth me pointing out we've focused on. The first is that we have, since OFSI was created back in March 2016, we have absolutely stepped up the amount of work that we do to work with businesses across quite a broad range of sectors, and to also work with other member states and partners. And I think that I hope will put us in quite good stead for the work that we need to do afterwards, where I think we will need to work very closely with industry and others who are operating within the UK's jurisdiction to make sure that there is clarity about, and it's sort of better understood, what it means to comply with the UK's regulations going forward, and that we can work to support some of that sort of coordination and collaboration that others have been calling for. The second is I'd sort of point to is really about the the work that we need to do to continue to really sharpen some of our day-to-day processes to ensure that we can manage the sort of the legal risks that that the previous panel was pointing to. Now we carry quite substantial legal risks now under the current circumstance, because if there are challenges to the way in which sanctions are implemented and enforced here in the UK, then they fall to us to defend and respond to those challenges. So there's been an increased resources put into this area from government, both not just in terms of the numbers of people and the diversity of skills, but also in terms of making sure that we've got increased powers to be more robust in the way in which we implement and enforce. And I think continuing to do that is an important part of being ready to do that, to be able to implement and enforce autonomous regimes going forward.
So one of the opportunities, it seems to me, under the new legislation is that you'll have a much wider discretion, as I understand it, to grant licenses and exceptions than was the case under is the case under the existing EU regime. Can you say anything about how that discretion is likely to be exercised and what changes people should see in licensing policy or expect to see?
So the sort of derogations set out in the EU regulations at the moment are very narrow and very specific, and much to the frustration, in particular to some of the law firms that we deal with on a day-to-day basis, that means that we must be very clear about not just the sort of grounds on which a license is considered and granted, but also the parameters that are stipulated around the activity that can happen under that license. And to a certain extent, I would expect that to continue under the new legal framework. But one of the most fundamental differences, and I think this is very much in response to a lot of the feedback and criticism and comments that we've had from industry and those who need to comply, is the introduction of a power to allow for more general licenses. And I think we'll need to wait to see what happens in terms of the secondary legislation and how that is described in the statutory instruments. So I wouldn't sort of automatically assume it will work exactly in the way that people are familiar with sort of OFAC's general licenses working, but it definitely does give much more sort of flexibility to the UK government in the way in which the sort of legal panel was discussing in the first session.
I wanted to ask Will Dodsworth, obviously without a route to funding, trade is very difficult, either pre or post-Brexit. How important is licensing to the banking sector? And do you have any comments on how well or less well licensing is working at the moment?
Thanks, Maya. So I think licensing at the moment, as Rena has touched on, is really challenging. So it's been a criticism of the current regime for some time that the EU licensing framework doesn't really work for the commercial sector. Trying to shoehorn a commercial transaction into extraordinary expenses is a work of art in itself. So I think what we're looking for actually is this really the provision of the general license and how that's going to work. And so I think for the commercial transactions, just a bit more latitude as to how OFSI positions its licensing powers, and then the need to go and seek permission from the other member states. Again, I think that's going to be a welcome diversion, so that's no longer going to be needed. I guess on the other side, there is also the opportunity for the UK, and it's going to be around perhaps the more forward-leaning approach that the UK might take on humanitarian licenses. So we've heard about general licenses, but you could have very specific project licenses where you'd hope you'd see alignment from the across government, so foreign policy objectives, funding from DFID, and that would need to align with both the NPO, the NGO sector, as well as the banks. So I think we're quietly quite confident that OFSI and government will take up the challenge and use licensing in the way it can.
So you, obviously speaking as you do for the whole banking sector, regard Brexit as an opportunity rather than an enormous compliance headache?
So I think if I'm looking at what additions could be sanctioned. I think the key factor we'll be looking for within the statutory instrument is we're going to look for clarity. So we're going to need, if something is going to be above and beyond the European European sanctions, then we're going to need very specific guidance that we'll need to follow. And also, we're going to need to build in a bit of an agility. So if there are unintended consequences, these can be picked up quickly and dealt with. So look, I think everyone in the banking sector is used to dealing with complexity. I think another regime is going to be another regime to deal with, another lens to look at it. But I think there is this opportunity for the UK to perhaps tighten its sanctions regime. So Russia is a good example where you could see, I know we've heard about the concern about the protecting the capital markets, but it does make sense that there would be a little bit more scrutiny on some of the Russian sovereign debt and how that's tackled within the city. And I think if you get that kind of forward-leaning approach, then actually the banks are there to enforce it. I think the key will be guidance and leadership when those decisions are taken.
So, and guidance is now a statutory duty on OFSI to provide. Rena, can you say anything about what we should expect by way of guidance and when?
So we're saying that the sort of statutory duty will extend beyond just the areas that we're focused on here, but guidance has been a really important compliance tool for OFSI since its inception. Indeed, it was pretty much our inaugural act was to publish some broad guidance, and we've continued to update that as we've gone on in response to sort of really drawing on some of the feedback that we receive pretty much day to day from industry and the not-for-profit organisations who are trying to make their way through it. So the commitment is already there, and we've been doing it and will continue to do it going forward. But I think one of the sort of in particular, one of the differences that occurs when we are in an autonomous regime is about the sort of the breadth of guidance that we can cover. At the moment, OFSI's guidance is very specifically limited to the way the sort of approach on implementation. We do not, and the UK government cannot provide sort of guidance on specific regimes or in other areas. So we've done as much as we can within as a member of the European Union to date, and I think there'll be some real questions going forward about how we can sort of use some of the opportunities to provide the sort of clarity that others have been seeking.
I mean, Will mentioned, I think what he was saying is that if one approaches a UK authority and has permission, has a license, that's obviously going to be a UK-only license. But has there been any consideration given to the possibility of sort of cross-border licenses and sort of cooperation with the EU between national competent authorities so that industries like those on this panel don't have to make multiple applications across the EU? So in short, that is the process at the moment. Because the implementation and enforcement is done by sort of at the domestic level, it is for each member state's competent authority to make those determinations. There isn't that sort of mutual recognition of the licenses, and you do need to apply for licenses to the relevant competent authorities. And therefore, I think it is difficult to, it is one of the questions and issues that has come up, but the fact that it cannot be done at the moment within the European Union means that I think it's difficult to envisage how that would work, either whether all EU member states would get to the stage where they're happy with that mutual recognition, and then to go a step further and have that recognition with the UK. So I think the extent to which that process would be quite costly and administratively quite burdensome is some of the considerations that have probably led to it being the way that it is today. I think if I understood Will's point sort of earlier, it was that in the current situation, there are some of the regimes which require
each competent authority to notify all of the other competent authorities and allow a time frame before we issue a license, so we can make a decision internally that we're content to grant a license, but then we have to notify and then we have to allow time. And there are some regimes both at the EU level as well as at the UN level where that is required, and obviously that will change if we are not then when we leave the European Union.
Susan, I wanted to ask you from the point of view of the obviously very international reinsurance market. We've heard from Andy some of the problems of compliance with sort of overlapping and sometimes inconsistent sanctions regimes. And what about where they're actually actively in conflict, completely inconsistent with each other? Because I know something of great interest to a number of people here is the so-called blocking legislation, where the United States says you must comply extraterritorially with our regimes, otherwise you'll be cut off from the US financial system. And the EU then comes along and says, well, actually, it'll be a breach of EU law if you choose to comply with the US system. So that's obviously a bit of a headache, to put it mildly. But is that further complicated by the possibility of an extra UK regime on top of that?
Well, I think, Maya, as you say, it's something we already have. That's not a new situation. So it really just adds an extra layer to the onion, you might say, because you're going to have one more regime. And I was very interested to hear Andy mentioning 3 regimes. I think that's a very conservative number, especially for a very international business, which reinsurance is. Though I would certainly say that we take account of an awful lot more than 3 sets of sanctions regimes, and I would think all international businesses do. So you could argue that we're already used to dealing with a multi-layer onion, but I would just say we really don't need any more layers to it. It's an added complication.
Out of interest, what you're talking UN, US, EU, possibly UK, and where else do you regularly have to look?
Well, fortunately, there is a high degree of commonality here, but a key one is Switzerland. But various other countries obviously equally have very strong regimes, and I mean Australia, Canada. There are a number of countries where the sanctions regimes do need to be taken into account. I think, one other point, just to circle a little bit back on an indirect impact of Brexit. I mean, obviously, financial services companies in the EU basically operate under the passporting regime, and of course once the UK goes out, the passporting regime changes, and I think everyone will have seen in the news a lot of information from different companies about setting up new structures, new subsidiaries or new branches in different countries. And again, this brings this extra layer of the onion, another set of the sanctions regulations into force. And the knock-on impact of that, as Andy said earlier, and it's exactly the same for my business as his in this respect, is the ultimate effect is to increase compliance costs. And obviously all firms struggle with that.
Tom Keatinge, we've talked a bit about the tension between trying to support trade, particularly post-Brexit, and the possibilities for different and perhaps tougher sanctions regimes. How do you think that's going to play out, and from what perspective have you studied that at RUSI?
Well, when you talk about Brexit, you're meant to have a sign behind you that says Global Britain that disintegrates slowly. And one of the elements, obviously, of Global Britain is trade. And so the question that we ask ourselves all the time is, what is the UK's geo-financial strategy? What is the UK's trade strategy after Brexit? And when you're not just relying on the private sector to implement sanctions for you, you're relying on the private sector to implement that trade strategy for you. So there's clearly, there's potential risk there. And when you hear the sorts of challenges that UK-based businesses face, then you have to wonder how that trade strategy can actually come to pass. So, not just because he's sitting next to me, but obviously just as the UK is meant to be going out and trading around the world, Barclays is retreating, for example, from Africa. So the reason that kind of action is being taken is because there is a long history of pain that financial institutions and others have suffered from sanctions contraventions, often at the as the result of the long arm of Uncle Sam. But nonetheless, you can't, I think, sit there and say we're going to be a beacon of integrity. We're going to use Magnitsky we're going to do all use all those sanctions tools that we've developed, whilst at the same time trying to encourage the private sector to get out there and do deals and be global Britain. So when you watch Liam Fox beetling around the world, and there's a website out there where you can see where he's been, he's not going to places that many companies in the UK are going to want to go and risk getting their fingers burnt. They're going to want to do business in the United States, they're going to want to do business in the European Union, and that means that actually our ability for companies to go out and deal in these new markets means they're going to intersect with bad people who, at the same time, we think we should be sanctioning. So I think there's a huge conundrum here, and I've yet to see any articulation from the government about how this sort of financial power, the economic statecraft, etc., is going to come together with this desire to be a trading nation.
I want to leave a few minutes for questions at the end, but I do want to just ask Rena the Harold Coe question, which is, what is the zeal with which these sanctions will be enforced? Because OFSI has been in existence for 2 years. There have been no public enforcement decisions yet. It has obviously made its mark, and there have been a number of reported breaches. I think 133 suspected breaches reported. We all figures last year worth around 1.4 billion. But will we see any sanctions enforcement decisions coming up? Does Brexit play a part in this or not?
So I think this is, probably a very valid question, sort of notwithstanding Brexit, and one that frequently arises. I mean, it's worth being clear that we take, there's one question which is about suspected breaches. Once we've determined that a breach has occurred, then we take action in every case. But from very much from my perspective, my objective is not to kind of impose the maximum number of penalties or at the maximum value. The new powers came into force and are and can be considered, and for any of the breaches that occurred after the 1st of April 2017. It's not a retrospective power, and we have also made a very clear commitment. The legislation requires us to use that in appropriate circumstances and to use it proportionately. So there are a number of tools at our disposal which we can take to improve compliance and to enforce, and the penalties is one of them. As we get kind of further and further away from that 1st of April sort of start date, I guess, for the new penalties, it becomes more and more likely that we will be using them as we see cases where the breach occurred after that date, but we will only use that power when it is the appropriate enforcement action to take, and we will not hesitate to use it where it is appropriate, but we will use it where it's appropriate, and we'll use it proportionately, and I think that's the right thing for us to do. In parallel, we will continue to work on making sure that we are working with industry and the sort of charities and others who need to comply with the regulation to make sure that there is a better understanding of what it means to comply, and to support all of the efforts to try and improve that compliance, because that is ultimately the goal.
I mean, the Act does give, again, an opportunity, the possibility for separate penalties, for additional penalties for breach of sanctions. Again, it's a discretion on ministers, and we'll see how that's exercised in the regulations. But you have fairly new civil fining powers. Yeah. There are already criminal penalties and extended reporting obligations, in particular on legal professionals, which will be familiar to people in this room. Is there anything else that you would like to see in your armoury while the ministers have the pen, or do you feel you have sufficient tools and just need to sharpen their usage?
So So it's worth saying, obviously, the Act, it is now an Act. We always have to keep sort of checking ourselves on referring to the bill, and therefore the powers that are set out in that, government and Parliament has agreed are the right powers for us to have in these circumstances. And I think from an OFSI perspective, I think it would be important for us to sort of test those and to work with our partners in law enforcement to really test the powers that we have before reaching to sort of to additional ones. So it feels like we've got that in place, and we will need to really test them undoubtedly as they are tested, not just in terms of our usage, but as a number of colleagues on the previous panels were rightly pointing out, as they are tested in our courts as well. I think we will undoubtedly sort of see some, we may come back to needing to sort of tweak and amend legislation in the future, but for now, I think it's quite clear those are the powers that we need.
Okay, well, we do have time for a couple of questions. I'm sure everyone's dying to get up to the river room for a drink, but are there any questions just before we break and move to the reception?
I'll ask a question, please. Tom Stalker from Pinsent Masons. Question relating to the EU blocking regulations. How do you foresee companies approaching the EU blocking regulations from a practical perspective? In particular, I'm thinking about the obligation to notify the Commission within 30 days if Iran-related business is turned down because of US secondary sanctions. And to tie the question into the topic of the conference, post-Brexit, would you like to see the UK legislation that implements the EU regulations remaining or being repealed?
Okay, does anyone want to have a say on implementation of the blocking regulation? Everyone's lips are sealed. Will?
Okay, I'll just say one thing. We will, of course, comply. But I will also make the point that was made earlier about the US having the most draconian sanctions regarding Iran, when it had no skin in the game in terms of, no business with Iran, which is absolutely true. But wow, did it swell its coffers a little bit, didn't it, by a few billion, quite a few billion. So we will, of course, comply, though.
But if I could take your second point about the UK's relationship with the EU. So the premise of what I would describe before is overall I'm not too worried in the context of sanctions, but there is something I'm very worried about, which does affect the sanctions. And that's the whole information sharing relationship that the UK is going to have with the EU, because it affects the intelligence. I mean, even the intelligence agencies are going through this discussion now in terms of MR6's role and how that's going to be done. In the private sector, it's very difficult, potentially, because the UK is going to become a third country, and the EU will place restrictions on information that's being sent outside of the jurisdiction. Now, in the context of managing complicated global sanctions lists, where a lot of the compliance departments potentially are global and they operate globally, it's going to be very, very difficult in terms of, what do you do about the US-Cuba sanctions when it involves a European Union citizen? And then you also enter into the General Data Protection Regulation on top of it. So there are contradicting regulatory regimes. That's going to be very, very tricky to navigate through. The public sector are exempt, of course, as they should be, but the private sector is not. And so as the eyes and ears on being on the front line of statecraft and other aspects is what legal certainty will we operate under? And that question really hasn't been answered yet.
Can I just, if you go back to when the banks were facing the big fines that they faced 5-7 years ago, there was obviously a concern from a sort of national security perspective almost that, how big a fine could HSBC cop before it would find itself in sort of capital difficulty. And so as I understand it, there is an argument that you can make that actually, you know what, I have to comply, or I need to comply with one of those sanctions regimes that's in the annex on a sort of security basis. So I think what we're going to end up seeing is European companies arguing with the EU about something that the US is forcing on Europe. I mean, that's for me the most likely outcome of all of this.
Will?
Just on the blocking, I think the first question is going to be, how is it going to be interpreted by member states? So what is the enforcement appetite within the UK versus enforcement appetite within France, Germany, and other jurisdictions? And I think that isn't clear at the moment. So I think it's in the annex. We can see the Iranian regulations that are included. I think it is highlighting, though, this discrepancy between what the EU determines as primary and secondary sanctions and what the US would determine. I think we heard earlier, if you're a US person anywhere in the world, or you cause a US person, or as a non-US person, you cause a US person to breach, you're on the hook. And so that doesn't change. I think the other element is we've got to remember that the sanctions against the Iranian Revolutionary Guard are still an EU sanction. You know, they're a state sponsor of terrorism. So there are going to be a lot of reasons to still not do business with Iran. It's going to be whether you choose to say that it's due to US sanctions. So I think there's the whole money laundering concerns. You know, they're still on the FATF grey list. There's a hell of a lot of reasons why you wouldn't do business with Iran. But I think it's going to come down to enforcement risks. So which of the regimes is going to bite the hardest?
Can I say one last thing? I think that actually you mentioned a very important point there, which is, you know, next Friday the FATF will publish their latest view on Iran, and I have to believe that there will be a loud hammering sound as the final nail goes into the JCPOA coffin, because the Iranians have made it pretty clear that they're not going to play ball with FATF anymore, and so the FATF, the Financial Action Task Force, will, I think, turn around and say, well, you're back on the major naughty step that we took you off in the spirit of the JCPOA, and that will be an excuse for people not to interact with Iran. So I think we're 8 days away from the JCPOA being absolutely dead.
Susan?
Yes, I mean, for me, all of this just adds more and more uncertainty, and that's what makes the compliance job so hard to do. We really prefer to know where we're going, and I particularly would just circle back to when Miriam was talking about the overseas territories and mentioned interpretation. Well, that's anything requiring interpretation is another area of uncertainty. I also picked up on, as Andy did, Harold's comment about turmoil, and I think from all of these comments in answer to that particular question, all of it adds to uncertainty, all of it potentially adds to increased levels of turmoil, and that's not good for a business.
Well, on that note, thank you all very, very much for coming. You've heard an awful lot from an awful lot of different people with different perspectives. I think overall the summary is uncertainty, turmoil, extra layers of onions, headaches, but possibly some areas of opportunity, not least for the lawyers among us. So thank you very much for coming, and look forward to seeing you upstairs in the River Room.